Good morning, ladies and gentlemen. Welcome to the Pennington County Planning Commission meeting of Monday, March 9th, 2026. Recommendations of the Planning Commission on certain items from this agenda will be considered by the Board of Commissioners at the regular meeting on March 17th, 2026 at 9:30 a.m. I usually tell everyone that is a meeting time, but they do have an agenda time for the planning items, and if you can check that, you won't have to wait as long. The Planning Commission utilizes speaker request forms, which are available in the back of the commission chambers during the meeting. First item is roll call. We have Lori on Zoom, and Ron's absent. You satisfied with that? We can go on. All right. Approval of the February 23rd, 2026 minutes. Have you all had a chance to review either on site, on the internet site, or in the hard copy of your agenda that has been submitted as a packet? If so, the chair would address a motion to approve the minutes from February 23rd, 2026.
So moved.
So moved.
Second.
Moved and seconded to approve the February 23rd, 2026 minutes of the Pennington County Planning Commission. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed?
Aye.
Motion carried. Approval of the agenda. The same goes for the agenda. You would have had an opportunity to view it on site or through your packet. Chairs would address a motion to approve the agenda as submitted and published.
So moved.
Second.
Moved and seconded to approve the agenda as submitted for the March 9th, 2026 meeting of the Pennington County Planning Commission. Discussion. Hearing none, all in favor of the motion signify by saying aye.
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 Opposed? Motion carried. Consent agenda. Jason, good morning.
Good morning, Commissioners. Jason Thennison, Assistant Planning Director. The following items have been placed on the consent agenda for action to be taken on all items in accordance with staff's recommendation by a single vote. Any items may be removed from the consent agenda by any planning commissioner, staff member, or audience member for separate consideration. The findings of this planning commission on certain items from the agenda are recommendations to the Pennington County Board of Commissioners, who will make the final decision. Agenda item 4A is conditional use permit review CUR 15-30 for Peaceful Pines or Peaceful Valley Hideaway LLC, William and Valerie Landis, to review a multifamily residence in a rural residential district, and staff recommends to end conditional use permit CU 15-30 with the applicant's concurrence. Agenda item 4B is conditional use permit review 17-01 for Al and Sarah Sutton to review a recreational resort on the subject property. And staff recommends to continue conditional use permit review 17-01 to the April 13th, 2026 Planning Commission meeting. Next agenda item 4C is conditional use permit review 18-18 for Real Simple LLC. Randy Dowdy is the agent to review a rental home park on the subject property. And staff recommends approval of conditional use permit review CU 18-18 with conditions. Agenda item 4D is conditional use permit amendment review CUR 21-52 for Campfire Cabins, Al Sutton. And again, staff does recommend to continue this conditional use permit to the April 13th, 2026 Planning Commission meeting. And lastly, conditional use permit review, amendment review 22-26 or 22-06 for Kent and Kim Dissey to review a gunsmithing business. And staff recommends to end conditional use permit amendment CU 22-06 with the applicant's concurrence.
Thank you, Jason. Anything that the staff from the planning department would like to have pulled?
No, sir.
Commission, same question. Is anything that commissioners would like pulled in the consent agenda? Anyone in the audience that would like to have one of those items pulled, A, B, C, D, or E, I believe it is? Chair to address a motion to approve the consent agenda.
Move approval of the consent agenda.
Second.
Moved and seconded to approve the consent agenda as published. Discussion from the audience. From the commission. Hearing none, all in favor of the motion signify by saying aye.
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 Opposed? Motion carried. On to the regular agenda, item A.
Agenda item 5A is conditional use permit COCU 26-0002 to allow an efficiency dwelling on the subject property. The applicant is Todd Lankenow. The property is located at 23212 Clear Creek Road. It is 3.02 acres zoned agriculture district. Access is off Clear Creek Road and there's no special flood hazard area on the property. When staff puts these in front of the Planning Commission, we do look at two sets of criteria. The first one lists the criteria the Planning Commission may consider in their review of conditional use permits. Staff did not find that there would be any detrimental effects to the neighborhood, which is table on the left-hand side of the screen. Table on the right-hand side of the screen is the criteria that must be met for efficiency dwellings, and you can see they're all checked yes. Staff hasn't found any issues with this request. Just kind of an analysis of the property. So in 2024, the applicant came forward and got a special permitted use to allow an accessory structure as a principal use on the property. He also received a building permit to place that structure. Staff did do a review of that SPU in November of last year and found that the applicant had converted that shed into living quarters. So at that point, we contacted him and told him he needed a conditional use permit, and that's the reason for the request today. This item has been in front of the Planning Commission a few times this year already because the applicant had failed to make the proper notifications to adjacent property owners. At the end of last month, we did receive the confirmation that he sent those letters out, so the request is in front of you now, and staff does recommend approval with conditions.
Thank you, Jason. Questions for Jason?
I have one. Jason, if you go to the next picture, down on the bottom, the sewer is there.
Correct.
Well, that's,
Yep, so that's when I did this site visit back in November. That's what kind of tipped me off that there were probably living quarters inside this structure. I saw that he had received a permit for that. So when I did my site visit, I kind of suspected to find what I did. And then I did talk to the property owner, and he said that he wanted to use it as a cabin. He has future plans to build an actual residence up there at some point, but he lives East River. He comes out here occasionally and just wanted a place to stay. So we worked with him and was able to get him to apply for this request for an efficiency dwelling.
so this is acceptable, having the sewer like this out in the open?
Well, it goes out to his actual drain field. Yeah, so he's got a septic permit for the property, and it is connected to that.
And what about cold weather? Or will he not be using that in cold weather?
Well, it's a pretty typical connection, I believe.
Okay. It just seemed a little strange for more of a permanent structure.
Right.
I guess I had the same question. I've never seen an above-ground connection falling into the lid. It's supposed to be below ground when it's a septic because of the baffles and the different things that are involved in the proper operation of a septic.
Sure, so the rest of the system is underground. It's just this connection point that's not. And if you'd like to continue it, I can talk to the septic installer and see if there was a
I guess
problem with
that'd be
that.
my opinion. I'm not in favor of voting a above-ground connection to a septic. Never seen such a one. I can't believe it meets the state requirements for plumbing.
Okay.
I don't know how the rest of the commission feels on that, but
I agree.
Mr. Chair,
go right ahead, Lori.
isn't there a concern with it freezing? It looks like it's a dryer vent.
No, there is one that's there that's black. Maybe Jason could tell us what that one is too. There's a black line running from a different direction, like it's coming from somewhere else. Is that the one you're talking about?
I believe that's his water line.
Oh. Oh, okay. Oh, so this is a PVC pipe?
Yes, I believe the white pipe that's being discussed right now are his drains from inside of the efficiency dwelling out to the septic system.
I
Oh,
think,
yeah, because you can see them, you can see them branching off there. To me, it looks metallic. It looked like a dryer vent. Okay.
I think you're correct too. There's a Y in the PVC, so it looks like it's
Yeah.
coming from the building. But I did notice that it's above ground, and that's, I don't know whether it meets the requirements of the state or not,
So
let
if you'd
alone
like,
ours.
so if you'd like, Chair, we could add a condition in there that the system be inspected at this point, because we are looking at the use on the property to approve that today. So if you'd like, we could add a condition that within 30 days.
I'll go with what the other board members would like to see on it. And as far as the motion, whether you want to continue, what Jason's asking is whether go ahead and add a condition that says that has to be inspected for proper installation versus a continuance. Is that,
Correct.
I'd say add it.
That would be
add the
fine.
condition?
That would be fine.
Yeah.
Can you come up with a little wording for us that would make you happy?
Sure, I'd say just within 30 days of approval, the system be inspected and approved.
By what, your environmental people?
Right, yep.
Who would like to make that motion?
I'll make that motion.
Is there a second?
Second.
Discussion from the audience, from the commission.
Mr. Chair?
Yes.
May I ask a question?
Go right ahead, Lori.
Jason, I thought I heard you say that you've seen this connection in other places that has been approved.
I am not the septic expert in the office, so I would like to defer to them. He's not here right now, so if we add that condition in there, we can run it to ground.
Or did I misunderstand you? I thought I heard you say that you have seen an above-ground sewer connection in the past.
I believe there are connections like this with mobile homes with skirting, so I would have to go back and double check that.
Lori, I understood.
So you're just not sure? Okay, I understand.
Not 100%.
Lori, I understood it that he saw that and it alerted him to look at other things involved in the permitting process. That's what I understood it was.
Oh, okay.
He had seen that.
Yeah, correct.
All right, let's first get the motion handled then before we talk about what we're going to do with the conditional use. All in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. So please go ahead and add that condition. Based on that, is there any other discussion with Jason regarding the conditional use permit? Is anyone here that wants to speak from the audience on this? Chair to address the motion.
I move approval of COCU 26-0002.
Is there a second?
Second.
Second.
Moved and seconded to approve COCU 26-0002 per staff's recommendation for approval with 12 conditions now, wouldn't it? Discussion from the audience, from the commission. Hearing none, all in favor of the motion signify by saying aye.
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 Opposed? Motion carried. And I've got to watch the numberings. 5B, I guess.
So agenda 5B is conditional use permit COCU 26-0003 for Olin and Joyce Floyd to allow our caregivers residence on the subject property. I believe the Planning Commission has seen this request before. I'll go through it briefly. Kelsey did present this at the last meeting. I think the only issue with this is that the property owners failed to post the required sign in the proper location. They had it up on their deck instead of out by the intersecting road. So again, you can see the zoning ordinance lists 7 criteria the Planning Commission may consider, and those are on the screen. There were no issues with that. These are photos of the subject property. You can see that the proposed location of the caregiver residence is identified in the top left, and the proper location of the sign in these photos as well. With that, staff recommends approval of conditional use permit COCU 26-0003 with conditions.
Thank you, Jason. Questions for Jason?
One, where is this modular? There's a picture of like a black SUV and a modular behind it. And then if you look at the other pictures, I don't see any of those with that modular in it.
I'm not familiar with what modular you're referring to.
You see the black SUV?
Page 4 out of 6, is that what you're
It's
talking
page
about?
50, if you take it down
Yes,
through.
on your,
I'm not looking at the same thing you guys are looking at, but I can step you through on this map here. It looks like the primary residence is here.
You've got a whole series of pictures, and it's one of those.
Okay. So this is the primary residence here. Proposed location is here in this red block where they're proposing to put the caregiver residence. I don't know how that translates to what you're looking at, but that is the proposal.
So the one with the driveway is the residence?
Correct.
That doesn't look like the picture of this modular. Maybe it is, I don't know. Did you see it, Charlie?
yeah, I never did locate that either, yeah, your picture, yeah.
It does look like that.
Is it?
This one, you can see the front of it.
Okay, if that's what it is, then that's it.
Yep, so the caregiver residence isn't out there right now. They haven't,
Oh, no,
they
I-
haven't
yeah,
moved the
that I see.
modular out there, so that right now there's only one residence on the property.
Okay. That's the way it is, no problem.
Any other questions for Jason? I just had one, have they made a decision, are they still gonna review whether they're going to try to use the existing septic through our environmental or put a new one in?
That I haven't discussed that with
I see
Kelsey
your-
to find that
your
out, but yeah, it'll go through.
Conditions allow them some time to review that, but I just wondered whether.
Yeah, so that'll get addressed during the building permit process when they come in for the actual modular home that they want to place on the property.
Okay. Very good. Any other questions? Lori? Chair to address
No,
the motion.
I'm good, yeah.
Thank you. Chair to address the motion on,
Mr. Chair, I make a motion to approve conditional use permit COCU 26-0003 with 10 conditions.
is there a second?
Second.
Discussion from the audience, from the commission. Hearing none, all in favor of the motion signify by saying aye.
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 Opposed? Motion carried. On to item number C, am I correct, 5C?
Yep, agenda item number 5C is conditional use permit COC 26-04 for South Dakota Department of Transportation. Mark Kirkby is the agent and Gary Eckert is the owner. And this is to allow a temporary parking lot on the subject property in a commercial district. And staff recommends to continue conditional use permit COCU 26-0004 to the March 23rd, 2026 Planning Commission meeting.
Thank you, Jason. Questions for Jason? Where's the park, we've got a lot of property that says subject property from the blue. Where's the parking go in there? You
Yeah, so I
know,
think we want to work through some details with the agent.
it
the
doesn't
property
fit
owner.
all of it, huh?
Yeah, before we put this in front of the planning commission, that's why we want to continue.
That's what I kind of wondered.
Yep.
All right. Any other questions for Jason? Chair to address a motion per staff's recommendation.
Make a motion that we accept COCU, or actually move it to
23rd.
2030. Okay.
Second,
Moved and seconded. Per staff's recommendation to continue conditional use permit COCU 26-0004 to the March 23rd, 2026 meeting of the Planning Commission. Discussion from the audience, from the commission. Hearing none, all in favor of the motion signify by saying aye.
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 Opposed? Motion carried. On to D, I believe.
Yes, so Cody Sack, Senior Planner. Item 5D is conditional use permit, COCU 26-0005. It's to allow an accessory dwelling unit. The landowner is Chad Timmer. I do believe there's someone on Zoom. I'm not entirely sure who, but there is someone on Zoom.
That's what staff had indicated to me. There is somebody on Zoom today.
The location of the property is 13834 Sudbury Ranch Road. Involves 11 acres. Current
And I
zoning-
asked you, we're supposed to kind of confirm that while we're doing our presentation. Can I ask whether someone's on Zoom for the item, the accessory dwelling unit for 260005?
Yeah, that's correct. This is Daniel, excuse me, this is Daniel Pozarski. I'm the general contractor for the project. I also have somebody in the lack of my presence there in person.
He just raised his hand, so we've got him pinned down too. So I appreciate
You
it,
got us
Daniel.
both.
Just bear with us while we go through our little bit of front end here. Go ahead.
And,
Thank you, Cody.
And Daniel is the agent for Mr. Timmer too for this request.
Very good.
So access is off Sudbury Ranch Road, and there is no special flood hazard area on the property. Again, the zoning ordinance lists 7 criteria that the planning commission may consider in reviewing the conditional use permit. It appears that they meet all the criteria. And then the zoning ordinance has 8 criteria for an ADU. The requested structure that they're proposing meets those requirements. This was routed around for interdepartment review. The Sudbury Ranch Road District came back and said they didn't have any concerns or comments from the road district since the ADU with the attached garage will use the existing driveway. Again, the applicant has requested a conditional use permit to allow an accessory dwelling unit on the subject property. As you can see, this is the site plan, the proposed structure. It's kind of hard to see, I guess, on this, but the proposed structure is right there. The existing residence is just to the north. And they are proposing a 1-bedroom ADU. Staff did a site visit. The property is well maintained. Current address is posted. Staff didn't really have any concerns. Staff did receive 1 public comment related to the request. I believe it's attached in your packet. It's mainly about renting an ADU. The zoning ordinance does allow an ADU to be rented. So I'm not sure what can be done about that, but they did have concerns about being rented, but it is allowed as a vacation home rental if they get the VHR license. So with that, staff does recommend approval of conditional use permit COCU 26-005 with conditions.
Questions for Cody? I got one for you. When you're figuring an ADU, I assume, the way I saw the sketches, we've got garages on an ADU?
Yeah, so an accessory dwelling unit, it's supposed to be a structure that's accessory to the property. It just, you're allowed to put it with a garage. The ADU limits your finished square footage to 700 square feet. That's really the only.
So you assume you're not putting the garages in the 700 square feet?
No, garage space is not considered, even though it could be drywall, that's not considered livable finished space under like ICC. So it's mainly just the living area. So like in this instance, you have a 16 by 32 living area. The garage isn't considered in that space.
Okay, and our ordinance allows garages on ADUs?
Correct, yes.
Okay, that's all I was getting at. Very good. Any other questions for Cody? And the applicant's here, do you want to come up or wait for questions? If we have any serious questions, then we'll get you up here, huh? Daniel? Anything
Yes, sir.
you would like to offer before we move on?
Just to touch on the rental side of it, as you had mentioned earlier, I believe this is, the intention is to be used for personal, not for rental.
At this time?
At this time, correct, yes, sir.
Which would go along with the one person that wrote in, but there, you did indicate, and I had read that as well, they didn't agree with rental.
Yeah, I don't, yeah, so the person who wrote in was fine with the ADU. They just had concerns with it being, as long as it was used for personal use. Again, the zoning ordinance allows ADUs to be a rental. The only way we could limit that would be if the landowner themselves wanted to put that restriction on there that it wouldn't be used as a rental. But it is their right with the ADU to rent it, short-term or long-term.
Okay. Thank you, good. Anyone else from the audience would like to speak on this one? Hearing no further questions for Cody, the chair would address a motion.
Mr. Chair, I make a motion that we approve conditional use permit CU 26-0005 and 14 conditions.
Is there a second?
Second.
Moved and seconded to approve per staff's recommendation to approve conditional use permit CU 26-0005 with 14 conditions. Discussion from the public, from the commission. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Thank you. Are you our instructor today?
Tyler Sobzak, State's Attorney's Office. Yeah, I suppose I am.
Well, good.
Got a lot of fun stuff regarding open meetings for you folks today. This is a deviation from how this planning commission used to operate. In the 2025, legislative session, the governor signed a bill requiring that agencies or political subdivisions of the state are required to review the open meeting laws every year now. So that's what we've got on your agenda today. The thought process behind that was a little bit of a combination of two things. First, there's a lot of smaller municipalities, counties, so on and so forth, that had never really taken an in-depth look of the open meeting laws. And additionally, the Open Meetings Commission hadn't met from a period of time from 2019 to 2024. So there were just a decent amount of uneducated public servants, let's call them. So that's what we've got today. The statute requires us to review any material prepared by the Attorney General for any specific given year. And so what that consisted of for this calendar year is just this: conducting the public's business in public, published by the Attorney Generals in association with the SD News Media Association. So all we have to do today is go through this pamphlet together, and I can stand for any questions kind of when I'm done. So Jerry, would it be possible to pull this pamphlet up on the screen? If it's attached to the agenda, I could probably do it on this end. Give me one moment. Oh, there we go. All right, so we'll begin. What are South Dakota's open meeting laws? The open meeting laws embody the principle that the public is entitled to the greatest possible information about public affairs and are intended to encourage public participation in government. SDCL 125 is the chapter that governs the open meeting laws, and that's kind of where we'll be spending the majority of our time, even though we'll be in 127 a little bit as well, and that deals with documents. 125 requires that official meetings of public bodies must be public, and advance notice is to be given of such meetings. Additionally, the statute defines an open meeting as one where a quorum of the public body is present and at which official business or public policy of the body is discussed or decided. Who does it apply to? All public bodies of the state and its political subdivisions. The county is a political subdivision of the state of South Dakota, and you are a branch of that political subdivision, so these requirements do apply to you as the planning commission. But generally, this includes cities, counties, school boards, and other public bodies created by ordinance or resolution. You are created by SDCL 11-2-2, just for your own knowledge. SDCL 125-12 subsection 2 is kind of where that authority comes from. Although no court decisions have been issued on this subject, this probably does not include advisory boards. I think someone like that would kind of be the wind and solar panel that Commissioner Small worked on. Are teleconferences considered public meetings? Yes, they are. Open meetings laws allows meetings telephonically, including executive or closed meeting, to be conducted by teleconference, which is defined as an exchange of information by audio, video, or electronic means, including the internet, if a place is provided for the public to participate. In addition, for teleconferences where less than a quorum of the public body is present at the location open to the public, arrangements must also be made for the public to listen by telephone or internet. The media and public must be notified of teleconference meetings. I don't really think that I can see a situation where that applies in your specific context. Ooh.
May I ask a question?
Yeah, go ahead.
What's the exercise sovereign power?
Sovereign power, great question. So essentially how I like to think of sovereign power are, you know, what's a good way of putting it? Powers that exclusively governments can kind of exercise. Taxing is the biggest sovereign power. So, you know, taxing and making decisions on behalf of constituents is kind of how I think about it in a thumb of reference. But essentially, if there's a political subdivision that has taxing power, that's the biggest red flag for me for it having some sort of sovereign power. And because, you know, the county commission has taxing authority and you have the power to dispose of conditional uses, rezones, things of that nature, you are holding some sovereign power as a board of the state of South Dakota.
The reason I was asking is I think of like board of directors of nonprofits and things
Sure.
like that have the right to charge their members or make, what would you say, fees.
Special
involved with
assessment,
it,
things of that.
And apparently that would not apply to that situation.
Yeah, and there is a little bit of a, you know, although some private entities do have the power to, you know, assess levies or other fees, that does kind of differ in the sense of true taxation. So that's kind of how I look at those two things differently.
Because they're related as a business.
Correct.
function.
Yeah,
Okay.
they're furthering a private.
I asked.
Yeah, a private purpose rather than a public purpose per se. How are the
Thank
public
you.
and, yeah, of course. How are the public and media notified when public business is being discussed? 125 1.1 requires all political subdivisions prominently post a notice and copy of the proposed agenda at the political subdivision's principal office. At a minimum, the agenda must include the date, time, and location, and must be visible, readable, and accessible to the public for 24 continuous hours immediately preceding the meeting. Also, if the subdivision has its own website, the notice must be posted on the website upon dissemination of the notice. For special or rescheduled meetings, however, political subdivisions must only comply with the meeting notice requirements as much as circumstances permit. That's kind of the catch-all for emergency meetings, essentially. The notice must be delivered in person, by mail, by email, or by telephone to all local news media who have asked to be notified. We primarily do that through the newspapers. Is it good practice for local media to renew requests for notification of special or it is good practice for media to renew requests for notification. However, 125 1.3 varies slightly from 1.1 and requires the state and its agencies, board, commissions, or departments to give notice at least 72 hours compared to the 24 hours. Not really pertinent to you, but still very interesting nevertheless. If we can go to the next page, Jerry. Who are local news media? Weirdly enough, there is no statewide accepted definition of local news media, but I guess the way I'll leave it for you is if it smells like local news media, it probably is. So we can go ahead from there. Is public comment period required at public meetings? Yes, every single time. We routinely have public comment period at the beginning of our meetings. It used to be at the end, but now we're doing it at the beginning. Can public meetings be recorded? Yes. 125.11 requires public bodies to allow recording if it is reasonable, obvious, and not disruptive. So essentially, as long as somebody is minding their own business, recording the meeting, and it's not a nuisance for the proceedings of the meeting or hearing being held, then it should be allowed. When can a meeting be closed to the public and media? Well, that's your executive session. 125.2 allows a public body to close a meeting for the following purposes: to discuss personnel issues, the consideration of the performance or discipline of a student or person or employee, consulting with legal counsel or reviewing communications from legal counsel about proposed or pending litigation or contractual matters. 4, contract negotiations. 5, to discuss marketing or pricing strategies of a publicly owned competitive business. 6, to discuss information related to protection of public or private property. But essentially, the one that's going to probably apply to you the most is that subsection 3, consulting with legal counsel or reviewing communication from myself about whatever matter. However, what is the proper procedure for executive sessions? You have to make a motion. Motions for executive sessions must refer to the specific state or federal law allowing for the executive session. If you watch any of the county commission meetings, you'll probably have noticed that I'm a stickler about the wording of this. The statute requires a citation, and when I'm in a briefing a matter and I have to cite to a court case, I have to specifically say what the court case is, what chapter it is, what page it can be found on, so on and so forth. So it requires specificity. So it's best practice, in my opinion, that you make a motion pursuant to 125 to subsection 3 for communicating with legal about whatever the legal purpose could be. So we really want that statute and that specific subsection in when you are making a motion for executive session. I know we don't go into executive session very often, but that is the biggest trip up for people when they get in trouble with the Open Meetings Commission.
Is that a motion that's open to discussion? I don't
Yes.
remember in Roberts whether that is.
Yeah, I believe it is. I think you have to be a little coy with the discussion surrounding it, but because you don't want to tip
That
your
no
hand.
information that belongs in the meeting is released during discussion,
Correct.
right? That part I could
Yep.
believe.
And when you are making an actionable motion following the executive session, you do have to actually, so you go into executive session, you discuss whatever the topic could be, and if it's an actionable item that you just discussed about, you do have to come out and then make the following motion from there. Any questions about that?
As I understand it, no action can be voted on or passed in the executive session regarding any one of these 6 categories.
Exactly.
It must be made in public.
Correct.
Is that the easiest way to put it?
Absolutely.
All right. So then, the only other question I'd have is you're asking us, should we desire to go to executive session, that we be more specific than just shaking our hands at one of the 6 rules? You're wanting a little more. Can you
Yep.
explain that one more time?
Yeah, absolutely. So it goes back to that citation requirement I discussed. So let's say we're going in to discuss some correspondence about a lawsuit that I wrote that you are getting appealed on. You could make the motion, I move to go into executive session under SDCL 125-2 subsection 3 for litigation purposes with our counsel, Tyler Sobczak, and that would be sufficient under the law. Although it's specific enough to let the public know that we're discussing a lawsuit, it does not need to particularly discuss the specifics of the lawsuit. You just need to give the public enough notice to know that that's the general topic that we would be discussing behind closed doors.
But you do want to refer to one of the 6 conditions
Absolutely.
that are required.
Yes. And that's just me being.
Does everybody understand that? Thank you.
Yeah, that's me being safe rather than sorry. There are plenty of people that just go into executive session making the motion for 125-2, but that word citation really trips me up. So that's why I require that specific subsection. But of course, it still needs to be on the agenda for us to go into executive session, so the public will have been notified through the publishing of the agenda and also the subsequent motion you would make at the meeting. Does that make sense? Okay. All right, where was I?
Official
Proper
votes
procedure.
cannot be taken. You were somewhere in around there, we're going to ask.
Yep, there you go. Can we go to the next page, Jerry? Maybe. There we go. What happens if the media or public is improperly excluded from a meeting? Well, that would be a violation of the open meetings laws. There are 3 options under law which a violation can be investigated. well, let me put it this way. After an investigation is concluded, a investigating state's attorney has 3 options. They can find no merit to the case, which is essentially a dismissal of the charges. They can charge it as a Class 2 misdemeanor, which is punishable by 30 days in jail or a $500 fine, or both, I suppose, or a reprimand in the Open Meetings Commission. You might remember Pennington County got in some open meetings trouble a couple years back, and that is the route that the prosecuting attorney took at that time. It was to refer that to the Open Meetings Commission, and they can give a public reprimand for any violations.
Can I ask a question?
Yeah, go ahead.
Who pays the fine and goes to jail?
You know, that's some. Well, let me answer it this way. Nobody has ever been prosecuted in South Dakota for violations of open meeting. Every single one has gone to the Open Meetings Commission. So I don't know your answer, Commissioner Litzen. It's never happened in the state before. So it probably never will, frankly. Judges are not as, how do I put it, educated in the open meeting laws as the Open Meeting Commission is. And it seems like that's the place where 100% of these end up going if merit is found through the investigation. I don't know, that's an interesting question. I've never thought about it though. All right, how are issues referred to the Open Meeting Commission? Essentially, it's like I said, a complaint is lodged with the state's attorney of the respective jurisdiction, and then it's investigated, and then when cause is found that a violation has been made, the state's attorney has to make it's called a referral to the Open Meetings Commission, where both parties essentially have their day in court to discuss what did or did not occur. And then the commission contemplates what actually happened and to decide if that's a violation of the open meetings laws. Normally, each side gets about 15 minutes to present their case, and the Open Meetings Commission deliberates from there, and all of that is held in peer, and you can listen to them as the proceedings are going if you're just an interested layperson. Well, there you go, Charlie. What does the term sovereign power mean? The open meeting laws do not define this term, but it generally means the power to levy taxes, impose penalties, make special assessments, create ordinances, abate nuisances, regulate the conduct of others, or perform other traditional government functions. May agenda items be considered if they are added less than 24 hours before a meeting? Proposed agendas for public meetings must be posted at least 24 hours in advance of the meeting. The purpose of providing advance notice of the topics to be discussed at a meeting is to provide information to interested members of the public concerning the governing body's anticipated business. Typically, the public body adopts the final agenda upon convening the meeting. At the time the final agenda is adopted, the governing body may add or delete agenda items and may also change the order of business, and they cite a case in Yankton regarding that. New items cannot be added after the agenda has been adopted by the governing body. However, public bodies are strongly encouraged to provide at least 24 hours notice of all agenda items so as to be fair to the public and to avoid dispute. Our county is generally not in the business of adding new topics, so I don't really think that applies to you.
That's what I was going to ask. It's been my understanding, having been chaired a number of these, that in regards to the Planning Commission, we have significant requirements about publishing that relate to 30 days, 10 days, this sort of thing, that it would not be wise to waive a rule to add an agenda item. That's the way I understood. You're still operating under Roberts, but you'd have to waive the rules to put an item in there, and I'm not sure we should be doing it.
No, particularly for the Planning Commission's business. I mean, so much has to be noticed in advance of the meetings that I really think that hamstrings your ability to perform this practice. But, you know, in the county commission world, there certainly could be an instance where something gets on the agenda last second. We still don't do it, but I think this really is discussing more the county commission business rather than the Planning Commission business. Okay.
Thank you.
Go ahead.
Say, for example, somebody in the audience, before we approve the agenda, asks to, well, like Charlie says, is there any addition or correction to the agenda? And somebody stands up and says, yes, I'd like to add this. Then what position do we take to tell them?
Well, you know, I think if it's discussion about just an item generally, I think that would probably be permissible. But if there's any actionable decision or determination this commission would make, then I would stray away from that and just go ahead and make the public notice requirements for the whatever the topic may require. If it requires 30 days, 20 days, 15 days, whatever, then I think that wouldn't be actionable or proper for you folks to do.
Actually, I was going to refer to the same thing. If I was running a meeting and we had inadvertently not published such that media was excluded before I would send it, allow an executive session or discuss the item, I think I would say we're going to continue it. And
Yeah.
get it into the realm of where it was published, and then we haven't violated the media's rights.
Yep, I think that's right. And you know, this is getting a little in the weeds, but something that would not violate the open meeting laws could very well violate the requirements of 11.2. So, you know, you're kind of wearing two hats here. You need to be cognizant of 125 and also the notice and publishing requirements of 11.2. So it's just better to not add it for most things, to not add them last second. But general conversation around a topic, I think, is something that you could probably hear. But also, that's what the public comment period's for, too. If someone has a specific issue that they want to discuss to you about, they could use that public comment time as well.
We've done it within the last year on one, it's something to do with an ordinance amendment. We voted to continue it because it hadn't been published enough for the public here within the last year or two, I believe. Mm-hmm. So that would be more the direction. I think the planning commission, and what the commissioners do, that's their business.
Yeah.
But the planning commission, with its requirements for publication, concerns me when you're running a meeting. You don't just step outside of that zone very quick.
No. Yeah, I just think it's better to stick to the agenda for most things. And hearing information and not taking any action formally is a whole different thing than adding a CUP at the last second. You're probably violating open meetings and also the requirements of 11.2. So it doesn't happen very often, so probably not something we'll have to worry about. But if an issue comes up, one of us is always here to discuss it with you folks too. All right, moving on. Our email discussions meetings for purposes of the open meeting laws. Well, the definition of an official meeting in SDCL 125.12 specifically includes meetings conducted by, quote, electronic means, including electronic mail, instant messaging, social media, text message, or virtual meeting platform. A quorum of a public body that discusses official business of that body via electronic means is conducting an official meeting for purposes of the open meeting laws. However, electronic communications made solely for scheduling purposes do not fall within that definition of an official meeting. So essentially, if you're discussing scheduling via email, that's perfectly fine, but we want to stay away from the actual substance of the meeting via electronic means, especially with a quorum. What records must be available to the public in conjunction with public meetings? 125.1.4 requires state boards, commissions, or departments to make public meeting materials available on boardsandcommissions.sd.gov. And 127.1.16, which is the FOIA requirements, Freedom of Information Act. That's kind of the bread and butter for viewing and receiving documents related to a public body. 127.1.16 requires that any other public body must post meeting materials on the public body's website or make those material available to the public at least 24 hours prior to the hearing or when made available to the members of the public body, whichever is later. We always have ours up at least 24 hours in advance, so no issues there. 127.1.17 requires that draft minutes of public meetings must be made available to the public at the principal place of business for the public body within 10 business days after the meeting. These laws are in addition to any specific requirements for public bodies. Example, publication requirements in state laws pertaining to cities, counties, or school districts, and enforcement of public record laws contained in 127 are handled by separate procedures found in 127.35 rather than open meetings procedures in 125. And violations of 127 are also class 2 misdemeanors, punishable by 30 days in jail or a $500 fine, or both. What requirements apply to task forces, committees, and working groups? Task forces and committees that exercise that sovereign power term and are created by statute, ordinance, or proclamation are required to comply with the open meeting laws. Task forces, committees, and working groups that are not created by statute, ordinance, or proclamation or are advisory only may not be subject to the open meeting laws but are still encouraged to comply with to the extent possible when public matters are discussed. Ultimately, if such advisory task forces, committees, and working groups present any reports or recommendations to public bodies. The public bodies must wait until the next meeting or later before taking final action on the recommendations. That's found in 127 1.18.
Is that a new one?
I think
Can't
it's,
remember that you had to push it to the next meeting, but
yeah, I don't think I remember that one either, actually. They must have, there was a lot of tinkering with these laws in 2025. I'm wondering if that was altered at that time as well.
yeah.
It is interesting.
That means that sometimes when we have, because we get committee reports that are authorized either from us or the commissioners, and we used to take action sometimes on the reports right at the time, it means it's got to go on to the next round of our meeting. I'd not seen that before.
I don't think we've had any of that since in the past year or so either, though, but it's good to keep an eye on.
Huh.
Yeah.
Thank you.
Are public bodies required to review the open meeting laws? Yes, that's what we're doing here today. So that concludes the packet we're required to go through. I would note at the back of the packet is the laundry list of all the statutes that the packet concluded, just fully stating out those statutes or other authority through 125 or 127. And otherwise, I can stand for any questions you might have.
Okay, say for example, I've got a question on the packet and I pop an email on to Kevin and ask him, what do you think of this? And he says, I don't know, let's put one on to Charlie, and now there's three of us going back and forth. Are we treading on?
Yeah, I definitely think, this is a funny thing. So legally, you have not created a quorum, because that would be 4 of 7, I suppose. However, I do think that it goes against the spirit of the law. If you're discussing, a question between 1 or 2 of you, I think generally the law is going to indicate that that's fine. But I think that's also the reason we have these meetings. I think it goes against kind of the spirit of the law, and so I would recommend you stray away from discussing any pertinent deliberations you might have and just save them for the open meeting instead. Because the planning staff is going to be able to kind of shed light on maybe your concerns better than discussion among board members per se. Does that answer your question, Commissioner?
Yeah.
Okay.
Okay.
Can I ask a question?
Yeah, go ahead.
What about like when, I wasn't around then, but when you guys went on tours, like of the solar facility, did that have to have a public notice?
It did, yeah.
If it-
Yeah,
Okay.
we publicly noticed those just to give the public notice that did the planning commission go on those tours? I remember the board of
Sure did.
commissioners did. You did? Okay, yeah. So
Planning
those
commission
were
did.
publicly noticed, and the time of which everybody was going to be there was also on that notice as well. And I think you
Did
even had,
Actually,
Members
it
of the
took several
public-
of
did
them
members of
because
the
we were
public show
divided
up?
in groups.
Sorry, what was that, Commissioner
It took
Litzen?
several notices because we were divided in groups, and if I remember right, Jerry, you had to keep track of who the names were on what group when we published.
Oh, that's right. Yep. Yeah, either way,
So
so
did-
we abided by the public notice requirements for those meetings. Yep. Or tours.
So did members of the public actually show up during those tours?
I think they did.
We had some.
Yeah. Uh-huh.
Oh, okay, all right, just curious.
And they were invited they were allowed to continue on with us by the company that was putting on the tour.
That's right. Yeah, that's
Sure,
Commissioner
but they
Johnson's
made
right.
them wear the gear, same gear we had to wear, but
Yeah, I
they
remember
were
the
invited.
Mater. I remember the Mater showing up and a couple other people as well. So, any other questions regarding that, Commissioner Litzen?
No, because I remember a few years ago, it was in Silver City, I think. There was a person that wanted me to come out and speak with them. It was just me, though. So that doesn't require any sort of open meeting, correct?
Correct.
Just meeting with an individual?
Yep, exactly. Commissioner Ross Connect is pretty probably the best guinea pig of this. He goes to places and takes meeting and then puts it in the following meeting as well, so all the other commissioners can see what he's looking like. One commissioner doing that does not invoke any of the violations that we discussed here today.
And that's what I did when I came back to the next meeting. I let the body know that I'd been out and met with this person, and this was my, comment on it.
Yeah.
However, it do have, and it's not with your statutes, but Roberts says that you're supposed to announce that you In other words, share that with the rest of the commissioners. If I'm
Okay.
been on phone calls or had dealings with people on a published item of the agenda, I should not keep that from you.
I mean, that would be just if, like, let's say after we had a discussion and it got continued and then someone, as we're exiting, stops you in the hall, you really should disclose that information right at the next meeting.
Yeah, absolutely.
Based on Roberts, there's rules about what you should disclose to the other members, to you. I don't necessarily have to disclose it to him or the audience, but it says, and of course, the best place to bring that up is at the meeting itself. That's why I usually bring up, I think the latest one was I brought up that I knew Doyle Estes for 30, 40 years, but never done business with them, that sort of thing, when somebody's on. Because there's that hint as to whether you should remove yourself, abstain from voting. And at least to the other board members, that way they know why I'm considering not doing it. And in the case of Estes, I'd never done business with them, so just knowing them, I don't think is something that precludes my being fair about my voting.
Yeah, that's my understanding as well.
Okay,
That's some institutional knowledge for you right there.
yeah.
Any other questions?
No,
No.
thank
Okay.
you.
Okay, so for the one requirement we need to still have is we need a motion that essentially, I forget exactly how it reads, Jerry, but a motion to acknowledge the review of open meeting laws as required by SDCL 12513. So,
I would put it as well as receipt. I was gonna keep them, that we actually all received one as well.
okay.
I'd add that into the motion because I'm gonna keep those, copy of those. I'm probably not gonna have it shredded like Jerry always does with these.
Yeah, so that's just,
Everybody understand, as well as some training, who wants to word it? I don't often word one, I'm gonna try. That the planning commission, the seated planning commission acknowledges both receipt of and what's on the exact cover. I would use that as the general. I'll get to it here. Conducting the public's business in public, receipt of instructional guidelines, as well as setting through an instructional session with our legal counsel, and receiving hard copies of same, I guess.
could we tack on pursuant to 12513 as well to that?
Absolutely, yeah, that probably ought to be in there, because
I think
that's the
so.
one that you referred to in almost every one.
Yeah.
Okay? Does everybody understand that? You want to read that back? Did you get that close enough? You don't want to read that back, do you, Jerry? This- Second. How about discussion from the public? There isn't any. From the commission? We're gonna see it again next year, in other words, every year. It looks like it's an annual type
Yeah,
of thing.
we'll try to do it in early January, moving from here. This year got away from us a little bit, but we'll try to do it in January from here on out.
Any other discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Thank you
Thanks,
for
Commissioner.
your help there, council. All right, we're on to executive session, of which we don't need one, and we do list it. And just to point that out, why it's always listed there is that my understanding that has to be part of our agenda, otherwise we could not excuse ourselves or request a motion. One thing I hadn't checked was whether the motion to go in an executive session requires just a majority or whether it's a 2/3. I'll look into that before the next meeting. Is it a simple majority? Okay, thank you. County Board report.
So the Board of Commissioners concurred with the Planning Commission's recommendations from the February 23rd, 2026 Planning Commission meeting.
Any questions on that? Our public walked out during our training session, so we don't have any left for those listening to us. Items from the staff, the building permit report.
Yep, so we got the February 2026 building permit report. I believe our group got a copy of that as well. So I'll just key in on single-family residences. That's kind of a good indicator of where we're at. So no change from last year to this year, where we took in 7 single-family residence permits. But the year-to-date total, we're up 79%. It has to do with the Apple Valley subdivision build-out. So we took in a lot of permits this month, so you'll see an increase in that at next month's report. With that, I'll stand for any questions you might have.
Thank you. Any questions for Jason on the building permit report? Let's move on to item number 10, items from the membership. There's going to be, I guess I'm going to throw out, there's going to be 2 openings come up, and so I think you and I are both coming up. So if you do have other friends or people that are looking at sitting on this or planning, it's time to start thinking about it. It all ends up happening at the last moment, and it's tough for these folks to get thoroughly review it as well as to get motivated to serve. So I'm just going to throw that up. There will be 2 of us, and we both served 2 in a row, so there's going to be 2 openings coming up. Both of us can't raise our hands, so there will be 2 openings this time. In what, officially they review them in June, don't they? Jason, May?
Well, they are advertised in May.
Okay. I thought it's coming up pretty quick, so
Done in June.
it's time. What?
We're done in June, right?
Yes, we're done at the last meeting in June.
The last, okay.
Okay. Just wanted to point that out so that we don't, if you have friends, because there are people from time to time, I'm sure, call you guys just like they call me, and I'll try to get back to those in regards to serving on the commission. Anything else from the membership? Chair will address a motion to adjourn.
So move.
Is there a second? Moved and seconded to adjourn the meeting. All in favor of the motion signify by saying aye.
Aye.
Opposed? We are adjourned.